All right. Hi, everyone. Welcome back to this channel and to the Civil Procedure Lecture Series. Today we will be focusing on pleadings, what they are, how to draft them, and what rules of civil procedure apply to them. So this will be the first of two main pleading videos. This one's going to focus on statements of claim, which are pleadings originating from the plaintiff's side, and the next video will focus on statements of defense, which originate from the defendant's side. So we're going to get into it in just a moment, but before we do, let's just start with this piece by Colin Lachance. It's called "The Justice System is Not About Other People." And this one will really close off what we discussed last time and really bring us into the mindset of thinking about how to draft a proper pleading to achieve our end goal of justice. So Colin originally wrote this piece essentially as an anecdote about an experience he had working as an articling student. So he was doing this case with his firm. This was a child protection case, and they were trying to help a family maintain custody of their child. The child was currently being cared for by other people, and those people wanted to adopt the child. So that's kind of the background as to where this case originated. Now, there's a lot of value to this piece. We're going to get to the resolution of the case in just a moment. Before we do, this piece really shows something quite important in thinking about pleadings and civil litigation, and that is the variety that civil litigation encompasses. And we're going to talk about it in two ways. So in the first way, in the broad umbrella category, how it can mimic other areas of law like criminal law, but why it still falls under civil litigation, and also the breadth in terms of how many areas of law it actually captures. So let's take the case he was working on, this child protection case. You're representing people against a big state adversary, right? It's the state trying to essentially seize control of this child, put them in a different environment, which is not the original family's household. So this still falls under civil litigation. And as you'll recall, civil litigation is any type of dispute resolution process, which is not criminal, and that extends even into child protection contexts. So in some ways, this type of civil litigation may seem like it can parallel criminal law, right? You've got this really big power imbalance, first of all, between a state who has a lot of resource, a lot of time, a lot of helpful entities and power. And then you've got the litigants, the family who may not have as much resource and time and power. But you've also got some charter considerations. You've got really an entity versus a state rather than an entity versus another person or a company. So a lot of things really mimic and are similar with criminal law, but at the end of the day, this still falls under civil litigation. So it really shows how civil litigation can mimic other areas of law, but the umbrella is quite broad as to what it captures. Another way that it does so, this article, how it describes the variety and wide breadth of things involved in civil litigation, is that it kind of describes Colin's schedule, how he works through after this case is resolved. So another way in which this piece describes and speaks to the variety and wide breadth of things involved in civil litigation is through his experience outside of the case. So the Monday after this case was heard, he actually had to switch gears completely into a very different environment from family law, and he started working for a huge telecommunications client. So you can see this very dramatic shift from family disputes, which are very personal and the decisions affect people primarily, to this very broad regulatory area of law and corporate litigation where the disputes are between companies perhaps, and there's no one person affected by the decision, right? He's representing more of a broader entity. And this just highlights that civil litigation is not a one shoe fits all. It can be so broad in terms of who the parties are. They can be individual people, they can be corporations. The resources can be quite different. There could be a state involved, it could be somebody with a lot of time and money and resource, or somebody with very little. So civil litigation is a very broad umbrella, and it really captures a lot of different types of disputes, no matter how different they may seem. Now, another really important thing about this case ties into its resolution. So, in the case, ultimately what happened was the judge ruled in favor of the parents, so Lachance's client, and they ruled that the province wouldn't extend this guardianship, they wouldn't take away the child because the circumstances were improving. So, great, the family won. Awesome, they get to keep their child. Interestingly enough, however, the family actually ended up conceding to the province, and they ended up giving their child up for adoption anyway. And this is because by the time they had quote unquote won their litigation battle, the system had consumed so much of their financial and emotional resources that they really no longer had the means to maintain what they were fighting for. And this is really important because it emphasizes that many costs are associated with litigation and that the system, the fight that you're fighting for, may consume all of your financial and emotional resources as a litigant. This is especially true if you're paying a lawyer, for example, or a paralegal to represent you, right? Money disappears in the blink of an eye. You have to pay lawyer fees, you have court fees, you might have to cough up a retainer up front, which is a sum of money they will keep in trust to pay for the services they're offering you. So money goes quickly, and then on the other hand, you also have this emotional turmoil, right? You're in a formal courtroom, which you've probably never been in, so it's already quite a stressful situation. And then you have a very hard battle ahead of you. Let's say, for example, this child protection case, right? The litigants are in this courtroom where they're already uncomfortable for 1, 2, 3, 4, how many ever days. And through that time, while they're sitting in the courtroom, people are just going through evidence as to the deficiencies in the way they care for their children. So it really takes a toll on you after a while. And litigation really spreads you thin. So the fight, could be really worth fighting for, but you could end up losing more than you bargained for, or you might even end up losing more than you've won after you spend all this time and money and energy fighting. So this piece is important in that it also represents what we'd call a Pyrrhic victory. A Pyrrhic victory is this idea that victories can often be so high in cost to the victor that the victor might actually regret having fought the battle in the first place. And this is a good piece to have at the beginning of a course on civil litigation, and also when thinking about drafting pleadings, because lawyers and litigants alike instinctively try to avoid losing. It's an adversarial system. The emphasis really on who will win a case and who will lose a case. However, winning a Pyrrhic victory, meaning a victory where the cost was so high it outweighed the winning, is almost just as bad as losing. And sometimes it's actually worse for the client. So the kind of victory we have here is very disproportional, consuming of time, resources, money, and it can really kind of distance ourselves or distort what we're looking to fight for in the end. Of course, the decision to keep on fighting is the client's decision to make. So no matter what, at the end of the day, the primary consideration is, does this person want to keep fighting? But as we'll see, and as we're explaining through this piece, sometimes we need to kind of just give ourselves a little bit of a reality check. So this quote by Voltaire kind of sums it up for us. I was never ruined twice. I was never ruined but twice, once when I lost a lawsuit and once when I won one. So he's saying you can lose in a successful lawsuit just as much as in an unsuccessful one. And that pretty much sums it up, right? So this is what Lachance is really trying to emphasize, right? That the justice system is more about other people, and it's more than just about the steps you have to take to achieve your justice. It's about the actual justice itself. The system often seems like it's a draining process, right? There's a lot of steps to take, a lot of deadlines to meet, a lot of documents to draft. But the point of these steps and the ultimate goal is that you're trying to reach a just resolution. So in thinking about drafting pleadings, which is where we're starting now, the first step of this long journey, we need to make sure that at this step and every step, we maintain this ultimate goal or view to justice, and we don't get lost or sidetracked on the way. There's a principle called audi alteram partem, which the 2015 Ontario Court of Appeal case, Ontario Provincial Police and Mosher expands on. And this principle basically means that every party has a right to be heard by a decision maker, and they also have a right to be noticed, to receive due notice of a hearing. So they have the right to have enough sufficient time to prepare and present their cases fully. However, as we'll see, this good faith effort to preserve justice sometimes has the effect of actually running into access to justice problems. And we'll see throughout the course how the system tries to reconcile this with the demands of proportionality. All right, so let's move on to pleadings. Pleadings are the first step on the conventional civil action road. Remember, litigation can be kind of this long and winding road. From the time you decide you want to start suing someone here at the beginning of the road, you have a lot of steps you have to take procedurally and a lot of things you have to do to get to the end, which is your resolution through perhaps trial, if that's what you're aiming for. The very first step of this long and winding road is the stage of pleadings. So pleadings are the documents used to commence a civil action, a conventional civil action. They state who the parties are, the position of the plaintiff, for example, or the defendant, what they're looking for, why they're suing, and the kind of compensation or relief that they're looking for. These are mandatory documents, meaning that all the parties to a lawsuit have to file them, or else there could be some consequences. Now, in the timeline of events of a civil action, the first step will be someone decides they want to sue someone else for a wrong. So A wants to sue B. A is the plaintiff who's making the claim, and B is the defendant who is defending themselves against a claim. So the first thing to start a lawsuit is A, the plaintiff, has to draft the first pleading, the initiating document of the process, which is called a statement of claim. That's going to start a conventional civil action. It's going to tell the defendant, this is who you are, this is what I'm suing you for, and this is what I want. When the defendant gets that document, they're going to file a statement of defense, which is going to follow, right? They're going to say, okay, I've acknowledged what you're suing me for. This is why I don't agree, or this is how I'm defending myself against your allegations, and this is actually my version of the events that unfolded. So it's kind of this documentary conversation between the plaintiff A and the defendant B. They're telling each other, okay, this is what you want, this is what I want, this is what both of our versions are, and they're setting the stage for the next steps. A handy website to know about where you can get templates for the more boilerplate language at the beginning and end of these documents, because they are in fact official documents, right? They go to another party, they may go to a court, is found at the website ontariocourtforms.ca. So if you are suing someone in Ontario court, you could look at this website. They have different templates for family law or the rules of civil procedure, because these pleadings are a little bit regulated in the way that they have to look. And you can get a template of the more boilerplate stuff you have to include. But we're going to go through it in just a moment to kind of outline that further. So again, we have a statement of claim followed by a statement of defense. And these together are the pleadings stage of this conventional civil action. Now, I do just want to make a slight clarification. There's a difference between pleading in the singular and pleadings in the plural. Pleading, singular form, describes statement of claim, for example, it describes a document, one thing. Pleadings, plural, refers to the phase of litigation. So drafting the document, you're drafting a pleading. If you are saying we're in the pleadings stage, you're talking about this overall documentary conversation that's happening at this stage of the litigation. So there's some basic rules on pleadings in the rules of civil procedure. Some of it is kind of the boilerplate language you have to include, which we'll get to in a moment. Other rules tell you how to draft, uh, when to deliver, things like that. Kind of the formatting and how you should be, the mindset that you should have when you're thinking about writing this down. And the main rules for statements of claim are in Rule 25 and its subsections. So to best understand these rules, we're actually going to read through some of them and go through them through an example of a statement of claim so we can identify how the rules of pleadings are used within it. So let's start by first introducing our statement of claim, who the parties are, and the dispute in question. So this is our statement of claim. This is our first page, the very top of the first page. And in this example fact scenario, the plaintiff, the person who is starting the lawsuit, who is suing, is this Adam Applesauce individual. And the defendant who is defending the lawsuit is Eva Evergreen Ltd. It's a company. So who are these parties? So the plaintiff is described as a seasoned accountant who carries on a specialized practice in large business bookkeeping. He has a bachelor's of commerce in accounting and finance, and he's had a practice for 20 years prior to his employment, presumably with the defendant, where he led private practice. He provided accounting and financial services to large companies. Great. So that's the plaintiff. The defendant, on the other hand, is a company, and they're in the business of selling home appliances. All right, great. So we know who the parties are now. So what's the issue? Now we move on to the next page. So we have an overview here of what the issues are, what the plaintiff is essentially suing for, what their version of events is. So what the plaintiff is claiming is that the defendant hired the plaintiff to do their bookkeeping under an exclusive contract. The plaintiff is alleging that the defendant told him if he quit his private practice and worked exclusively for them, meaning he ended all his other contracts and he focused on this company, they would make it worth his while. And they would provide him all the perks he had when he was self-employed. So they promised him specifically things like a senior lead position, a flexibility in his hours of work, comparable salary, a high volume of work. All of these great things in exchange for his exclusivity. So the plaintiff is claiming that the defendant promised him all of these great things, and that that's what they represented to him, and they assured him in accepting this job. And we learn later that he actually quit his job and he accepted the position with the defendant. Now, the problem, the reason why the plaintiff is suing is that when he took the position, these representations and promises were actually not honored. They were made negligently. The plaintiff was persuaded and ended up in a worse position than when he started. And that they displaced him in the peak of his career and they used his expertise for their own benefit without giving him what they promised him to take this job. So this is really the thrust of what this lawsuit is about. He's saying, you promised me all this stuff and you didn't deliver. And later we're going to learn that there's actually a lot more to the story. So he ends up getting fired. And in getting fired, he's suing. He's saying, well, this is not lawful because you should actually be giving me money for all the things you promised to do and didn't do. We'll see later the company has its own version of events. The company is claiming, well, actually, we fired you because you just didn't really measure up to the expectations we were looking for, and you didn't end up doing the work you were supposed to. But this is at a later time. In this moment, the plaintiff is the first person giving their version of events, and the plaintiff is saying that he was wrongfully terminated, he deserves what he should have been promised and compensated for what he didn't receive. He's saying that the promises were careless, and on top of that, he's actually adding more to this claim. He's saying, not only did I not get what I was supposed to, but I think that part of it, or part of why you terminated me, was because of discrimination on the basis of religion. So we'll learn he's a very avidly religious man. He needed time off to observe religious holidays, which the defendant allegedly agreed to. But then when he tried to take his time off, people gave him difficulty, disbelief, and they eventually terminated him. So a lot of things going on here. On the one hand, there is these promises that weren't kept, these representations that were made and not realized. And on the other hand, the plaintiff is saying, you also discriminated against me in several instances during this time, and the ultimate dismissal was motivated by very malicious intent. So this case has a specific personal issue, but it also has a broader social issue, which is discrimination. All right, so that's basically what the case is about. Let's begin going through it. So every statement of claim will look in some respect like this, especially the first few pages. You're going to have this thing we saw at the top, which outlines who the parties are. The court file number will be different because every case is different. You're going to have here statement of claim. The word amended, don't worry about it too much. We'll talk about it later on. But it basically means that this is the second version of this document where they actually went back to make some changes and they underlined those changes. And then you'll get this kind of boilerplate language over here, and it continues up until here. You'll have the date, the issuance, and the parties. If there's more than one party, you will say to party A, to party B, etc., depending on how many parties there are. So these first couple pages are very boilerplate language, and you don't have to know all this or type all this. This will all be present in the Ontario Court Forms website that I was talking about earlier. This is something you must include in all statements of claim, and the statements of defense will have their own kind of introductory boilerplate information. And it's meant to put the defendant on notice that the litigation is serious, you better pay attention to this or bad things are going to happen to you and you're not going to be able to defend yourself. So this is actually really helpful if you are a self-represented litigant and you've never been through this before and you don't really know what it means to be sued. This kind of outlines to you something is started against you. If you wish to defend this proceeding, this is what you have to do. And if you don't defend the proceeding, this is what happens. All right, so we have our initial few pages, boiler language, and then we have our claim. This is the first written paragraph that's a little bit more original to your statement of claim. Now, what is a claim? This is going to be on the first page after this boilerplate language, and it's going to tell the defendant what you as a plaintiff are looking for, what you're suing for, whether that's financial compensation, acknowledgement, or etc. What you want, what's the purpose of you launching this lawsuit? So in our claim, the plaintiff is asking for quite a few things, right? Some monetary compensation, a declaration that they were discriminated against, and then some other things that do end up on all statements of claim that are a little bit more boilerplate, but just in various ways. So let's really break this down a little bit. Let's start with these damages. So here we have three types of monetary damages. There's this amount, and this amount, and this amount, and they're all different. Why are they all different? What do they mean? What are the differences, and when can you claim each one? Let's start with general damages here. 1A, general damages. General damages are compensatory in nature, meaning that they want to pay you for what you lost. So these damages really have to do with what you would have made if you hadn't suffered a wrong. So in this case, What would he have made if he hadn't been lured to this company and he had kept his booming private practice? If he had lived in an alternate reality where things just had continued the way they were, and he was on track in life, and he wasn't displaced by this event, what would he have made? What did he lose in choosing to pursue this alternate route? Now, when you write a statement of claim, you aren't really anticipated to calculate exactly how much you've lost because there's really no true way of knowing exactly what you ended up losing. There's no way of knowing where your career would have been. There's no way of knowing anything really because nobody can predict the future, right? So you have to put a number down that you think is reasonable and keep in mind that this number might change. Perhaps you want to aim a little bit higher. It doesn't mean that you're going to be awarded all of it, but maybe you want to aim high if you think that you deserve that amount. So you want to broadly write what you're looking and aiming for in terms of general compensation for what you've lost. You want to restore yourself. The next type of damages we'll look at is 1C, aggravated damages. Aggravated damages are also another type of compensatory damage. So they want to kind of pay you for what you've lost, but instead of what you've lost financially, they focus on what you've lost in intangible losses. So what did you lose in terms of distress, humiliation, emotional loss, etc.? Not necessarily what you lost financially, but what you lost intangibly. Now note, if the parties are corporations, for example, if it's a company and a company, you likely wouldn't necessarily see aggravated damages because the parties involved, yes, they are losing money, but they're not necessarily suffering any kind of personal intangible loss, right? They're companies, they're not people. So at the end of the day, the judge will be the one who's going to quantify what they feel is reasonable in terms of what you've lost financially, but also intangibly. Punitive damages are their own category, 1B. Punitive damages are not compensatory, meaning they're not meant to pay you for what you lost, but rather they're meant to pay you extra amounts to punish the opposite party for bad behavior or doing the wrong thing, for doing wrong actions. So it's not really about what you lost. That's not why they're paying you. They're paying you extra for what you kind of had to endure to punish the other party for what they've done in terms of bad behavior or the wrong. So when a judge decides on damages, it's really unlikely to be these perfectly round numbers. You kind of pull a number out of the air when you draft your statement of claim, and you aren't really expected to specifically calculate your damages. The judge is going to do that for you once they determine if you have won. So all this to say that pleadings start a suit, and at this very early stage of litigation, a lot is yet to be determined, so the parties are not really expected to know with 100% accuracy what they're looking for in terms of compensation. And you don't need to, and we'll see this repeatedly time and time again, you don't need to know, you don't need to back everything up at this point with what you're saying or to get the details 100% right. So you need to kind of know what you're suing for in terms of what wrong has occurred, but you don't need to know how much that wrong entitles you to. When you draft a statement of claim, you can be relatively rough, and you can definitely err on the higher side for what you're claiming. Again, you might not get it, but you want to aim for what you think your best day in court might be, roughly speaking, and pick that number. A higher number could also be done or be used as a way to attract media attention. It can be that type of catalyst. So maybe you don't really expect this high of a number compensation, but you want people to know, it's a really big case, it's really high profile, I'm going to sue for this much. There could be a lot of reasons, to be honest, why the number is so high. But the important thing is, if the plaintiff does win at trial, no one's going to hold it against you what you wrote in the statement of claim. So no one's going to look at you and say, okay, you only got 1 or you only got 2 million or 3 million at the onset. We're capped by this number. No one is capped by the number in their statement of claim. the judge is free to award less than what you've claimed, and they can actually even award more than what you've claimed. So it isn't a cap by any means, and the plaintiff isn't expected at this stage, before the evidence is even presented, to precisely quantify how much they're entitled to. Okay, great. So the next thing we have here is 1D, a declaration that the defendant discriminated against the plaintiff on the basis of the plaintiff's religion. This is kind of setting us apart from regular statements of claim. We threw this in there because it's something that you could see, but not necessarily something that is typical. A declaration is basically saying, I want the defendant to declare officially that they've committed this wrong against me. I want them to put it out in the open that they've done. I want them to admit to this. And a declaration is not necessarily something that you may want to ask for. You can ask for it for multiple reasons. It could just be a personal reason. It could be for reason of looking for further employment. It could be for many things. But in this case, it's telling us that the plaintiff wants this to be more than just about a case of broken promises. They want to expose and uncover some kind of broader, bigger discrimination in a big company. All right, so next we have 1E, prejudgment and post-judgment interest in accordance with the Courts of Justice Act. Prejudgment interests reflect the fact that even if a judge orders that the plaintiff should get, let's say, $12 million, he is still out of pocket because some of those damages accrued a while ago. So think about it. The plaintiff started losing money and income the day he was fired. So the time between him being fired and him actually getting the judgment could be 5 years, 10 years. It could be a long time before he gets compensated. However, over that time, he has lost the value of the money for that time. So prejudgment reflects the fact that the plaintiff should have had that money before the judgment. On the flip side, post-judgment interest reflects the time value of money after a judgment. So let's say the plaintiff won their case, but they weren't paid until 5-10 years after the case. So the judge may say, you deserve the value of that time, and we're going to get the defendant to pay you that money if he doesn't pay up right away after judgment. All right. 1F, costs to be fixed or assessed on a substantial indemnity basis. So costs are extra money a plaintiff wants a defendant to pay to compensate them for the difficulty, the aggravation, and the financial expense of having to sue to get their rights vindicated. So the plaintiff is saying, look, it took so much time and effort to get to this point. I had to expend so much resource. I want you to pay me for some or all of that resource and money that I expended. So in this case, it's assessed on a substantial indemnity basis, but it can also be on a partial indemnity basis. Partial indemnity basis is kind of what the regular costs are, but if the defendant did something especially bad or egregious, you may want to bump that up to a substantial indemnity basis. You're saying, look, I'm asking for a larger cost award from you, defendant, to compensate me because you have just made this process so long, so difficult, and I've had to spend so much money to get my rights vindicated. All right, and finally we have 1G, such further and other relief as this honorable court may deem just. So this phrase essentially is saying, you're telling the judge, if you feel there's something you should throw in there to make the defendant compensate me properly, you go ahead and you add it in. The more the merrier. Whatever you think I should be compensated, you go ahead and add that into the pool of money. But the question now is, why can't we just have this section? Why do we need to kind of outline specifically what we're asking for instead of just saying, I've been wronged, and judge, you go ahead and you determine what you think I deserve in this case? Well, it comes down to a rule in the Rules of Civil Procedure, Rule 25.069, which states the nature of relief. So basically this rule is saying that whatever you're claiming in your claim has to be specified. And if you're claiming damages, you have to be specific as to the amount. It doesn't have to be accurate, but you have to be specific. You can't just tell a judge to give you what they think is just. You need to be kind of a little bit more precise about it. And the reason is, which is the same with a lot of rules of civil procedure, is that it's trying to encourage settlement. So requiring specific things you want to be part of your claim is going to help you potentially settle earlier instead of going through this long-winded process of litigation and expending so much time and money to get to the end. And the rationale is, if as a plaintiff you're specific about what you want, the defendant might look at that and say, okay, actually, that's not bad. I can concede to what you've said, and I can give you and meet you halfway or give you this amount of money to settle the case early. So it's really a means of encouraging this early settlement, being very honest with the parties about what you want and what they're able to offer, instead of really having to strap your boots and haul through this very long-winded civil procedure route. As we've seen, it can be a very long and winding road. Okay, so that's briefly our introductory pieces here. Now let's really get into the meat of the statement of claim, and we're going to look at some more specific rules of pleading and drafting. The first rule is material facts, Rule 25.061. Every pleading shall contain a concise statement of the material facts on which the parties rely for the claim or defense, but not the evidence by which those facts are to be proved. Okay, so that's quite a mouthful. But basically what it's trying to say is that material facts are the facts that establish your story and your account of what was done wrong. And you need to tell the other side and the judge through your document what those material facts are. So if you think of your statement of claim as a story, right? Your damages, what you're seeking, and your wrong is kind of your end point. You're concluding it by saying, this is how I was wronged, and this is what I want for being wronged. So material facts are those pieces of information or those checkpoints almost that you want to hit to tell the other side and the judge why and how you got to this conclusion. So the material facts are what you're relying on to establish that you deserve something and why you deserve something. Now, in outlining these facts, you can't bring in evidence. So you want to stick to facts like statements without going so far as to proving that statement. It's a very fine, subtle distinction, but hopefully we can work through a couple examples to make this a little bit clear. So let's just take a very, very basic example. A fact would be something like, it's a nice day outside. Whereas evidence would say something like, it's a nice day outside, and I know this because it's 30 degrees, I have my thermometer, I've measured it, and I see that it's sunny. So both of them are kind of concluding that it's a nice day outside, but one is very specific, whereas the other one is more of an assertion. You want to give people a sense of what you're planning to sue for, but you don't need to show yet how you're going to prove it. So you want to stick to the facts, not the evidence. And you want them to be material, meaning you want them to be important to your claim, not just like random facts that don't really don't really build up to your conclusion. So again, subtle distinction, but it's really important because there's going to be a time later to get everybody's evidence out on the table. But at this point, remember, right now, we're in the very first stage of documentary conversation. It's very early on in the game. You don't need to be too specific. At this point, you don't need to know everything. And the other side doesn't need to know everything either. We want to know why you're suing us, and we don't need to know yet what information you're going to use to prove that any of what you're saying is actually true. So let's use our legal example to really break this down. At paragraph 6, it states that prior to accepting employment with the defendant, the plaintiff was a seasoned accountant, had developed specialized practice in accounting and financial counseling services, had a Bachelor of Commerce, etc., etc. So these are material facts. They're material in that they're important to bringing on the claim, but why are they really important, right? Like these are facts that kind of pertain to a time before the plaintiff even started working with the defendant. So why is it important to mention all this? Well, you want to plead, you want to state specific facts to support your conclusion. So in outlining these facts, the plaintiff is trying to show what he left behind as a result of the promises made. So if his conclusion is that he relied on these misleading promises, or that he was poached by this company and that they used their expertise and that he was in a great stage of his life before he came to this company, he needs to show that. It's material to his damages because it shows what he lost and it adds credibility to his story. If he hadn't done much before accepting this offer, we'd have a really hard time selling that he was specifically scouted for his expertise, or that, he was in the height of his career before this whole fiasco happened. So it's really about credibility, but it's also about building those roadblocks, building those checkpoints that build on each other to lead to your conclusion. And again, it's material because it directly speaks to, when put with the other facts, to what your conclusion is and that you deserve damages for the wrong that's been done to you. A fact that is not material, that is a fact but just not important, is if it said something like, he's an avid golfer. All right, that's a fact, cool. But it doesn't really speak to anything important to the conclusion of this lawsuit. So you wouldn't want to add kind of irrelevant, immaterial things like that. Now, it is kind of a fine line. So why does this not count as evidence? What would evidence look like in this case? So for example, if your material fact is about your reputation, that you're a seasoned accountant, you had a specialized practice, what should you say, or rather what should you avoid saying so that your facts don't kind of cross that line into evidence? So this is not evidence, this is a fact. He had a bachelor, he was specialized, he's an accountant. Those are statements. Where you kind of get into the line of evidence is when you try to prove these statements to be true. So you say things like, I was awarded Best Large Business Bookkeeping Accountant in 2018, or my pay stubs show an hourly rate of XYZ. That's how you know I was specialized or seasoned. Or I was highly sought after, and I can prove this because I have references from past clients. So again, very fine line, but you're trying to claim facts without going so far as to state things that will prove those facts, like quantifiable, measurable stats, or kind of documents or direct quotations that just add too much specificity to what you're trying to say. If you broadly speak about your specialization or qualifications, this adds credibility to your claim. It shows that you actually lost quite a lot by taking on this new work. However, it doesn't go so far as to say or to prove how great you were and how much you've lost in terms of quantifiable money or stats. All right, I know this is quite confusing, but hopefully as we work through some more rules, it'll get a little bit clearer. So the next rule we're going to look at is Pleading Law, Rule 25.062. A party may raise any point of law in a pleading, but conclusions of law may be pleaded only if the material facts supporting them are pleaded. Again, a lot of words, we're going to break this down. What is a point of law? A point of law is anything in a pleading, any assertion that a legal right has been violated, or that a particular statute applies, or that is described through a legal analysis. So basically, they are legal arguments to be made. Your lawsuit can focus on one or many points of law. So let's pull up our example here to explain some of these things. A point of law is a legal argument. Some common points of law you might be familiar with are things like negligence, reliance, breach of promise, breach of contract, maybe even discrimination. So these are legal arguments that you're going to try to show. So when we plead the law, what we mean is that we are asserting that a particular legal conclusion, like negligence or a breach of contract, should apply. So you want to identify what those legal arguments you're going to argue are. But again, you don't want to explain specifically through evidence. So you want to explain what legal conclusions apply, but you don't want to go so far as to explain the actual law that goes behind why it applies. You're making a statement, you're not bringing in evidence. So at this stage, you don't cite the law, you don't cite statute, you don't cite case law to show why your case falls within any of these points of law. Rather, you're just stating that it does. And then you're going to use your material facts to support it. All right, so next we have inconsistent pleadings, Rule 25.064. A party may make inconsistent allegations in a pleading where the pleading makes it clear that they are being pleaded in the alternative. Essentially, sometimes when you start a claim, you know you've been wronged, but you're maybe not entirely sure as to how. So you want a space to say, and the rules really help us with this. They give us a space to say that I've been wronged. That's my conclusion. I think it's because of A, but it may be because of B. So imagine the plaintiff comes into your office and he says, look, I've been unlawfully terminated, but I don't know if they planned to headhunt me and exploit me and then terminate me from the beginning, or if they hired me with honest intentions, but then through time they decided to make this plan and terminate me unlawfully. And you might not actually even know which is true, which version of events is true until much later when the evidence starts coming to light. Again, this is a very early stage in the litigation process. You're not expected to know everything to an exact measurement. The rules are really conducive to this in that it allows us to plead inconsistent pleadings, which basically means it lets us showcase more than one version of events. And this is really important, right? Sometimes things come to light, or you might change your mind. Maybe something becomes more clear to you, and you want the space where you can say, I've been wronged. I think it's because they broke their promises, but I also think that another way it could be so is because I've been discriminated against. So in this case, the discrimination is the inconsistent pleading. You would start this by saying, in the alternative, meaning alternatively to what I've already claimed before with the broken promises and misrepresentations, I think another way in which I was wronged was through discrimination. You can state what part of a rule or a code you're going to rely on in the future, but you don't want to start citing specific sections or law. Another thing I want to point out about the slide kind of correlates back to the initial page here. Amended statement of claims. So remember I said sometimes information comes to light or you've decided you need to change something in your statement of claim after you've submitted it because maybe you made a mistake or maybe you've realized you wanted to add something that wasn't there before. You can do so. The rules are conducive to allowing you to make your changes through an updated version of this document where you title it as an amended statement of claim and you underline it. So in this case, our inconsistent alternative pleadings are underlined here also with the numbering. This means that we actually came in after we originally sent this document out and we added this. Maybe it came to light that there was discrimination, so we wanted to add it as an alternative reason to sue, an alternative version of events. And so we're allowed to do so, but we just need to kind of specify what we've changed from the first time. All right, so the next rule we're going to look at is 25.067, documents or conversations. The effect of a document or the purport just is an old word. That means the meaning or thrust of a conversation. The effect of a document or the meaning of a conversation, if material, shall be pleaded as briefly as possible, but the precise words of the document or conversation need not be pleaded unless those words are themselves material. Again, a lot of words, doesn't make much sense, but we're going to break it down. Let's say there was a particular conversation that showcased the plaintiff was promised X, Y, and Z. You want to plead, meaning you want to state as a fact that that conversation happened, because it helps you in building the stamina for the conclusion that they didn't deliver on a promise. So you want to plead that conversation happened, but you don't want to be too specific that it becomes evidence. So you don't want to turn your pleading into a transcript of the conversation. So the way this happens, the way this works with a document or conversation, this rule is saying if it's an important conversation, you probably want to mention it, but you don't want to specifically explain what was said in very specific terms. So let's break it down in an example. The defendant is saying here, for example, that the defendant promised to pay him handsomely and honor any working request he had. So this is a conversation they had during the initial interview, right? It's kind of outlining the key points, the meaning of the conversation. The conversation persuaded them to terminate his contracts. The conversation saw them representing themselves as a large bustling business. The conversation led to a promise that the volume of work would exceed what he was handling, that he would be paid handsomely, that he would have flexibility. So again, the meaning, the thrust of a conversation is important because it really ends up showcasing what he lost or what he wasn't given. And it's being pleaded in a way that it's being specific as to what was promised and what wasn't delivered. But it's not going so far as to say, in the interview in November 2009, the defendant said, quote, "We are going to pay you X, Y, and Z amount of money. The volume of work will be exactly so and so and so." Word for word, right? So you want to explain as a fact the document or conversation occurred, but you don't want to plead it in a way that it's too specific. So let's say in the claim of discrimination, would it count as evidence to state specific instances in your pleading about discrimination? So let's say there were specific dates of interactions that were discriminatory, or there were specific dates where you brought up concerns to HR. Does bringing up those specific dates and instances consist of evidence? And the answer is no. These are material facts because they are statements. They're a little bit more specific, but they're still statements of fact. You're not going into exactly what was said through a quote or a document that shows this statement to be true. All right, so the next rule we're going to look at is 25.06 subsection 8, nature of act or condition of mind. Where fraud, misrepresentation, breach of trust, malice, or intent is alleged, the pleading shall contain full particulars, but knowledge may be alleged as a fact without pleading the circumstances from which it is to be inferred. This rule is basically saying if you're making very weighty allegations, so you're saying the defendant defrauded me, they misrepresented, they breached my trust, there was malice, your material fact should be particular and specific enough that you can kind of back up what you're claiming, but you also don't want to be too specific so that you can actually plead the circumstances. You actually provide evidence of specific circumstances in detail. So again, very fine distinction between material facts and evidence. It is quite difficult to grasp sometimes, but remember that at this stage, we're not proving anything that we state is true. So a material fact would say, this person defrauded me, they stole money from me, for example, but you wouldn't want to say specifically with evidence how they did that or why you know that. You want to say what's happened, you want to state it as a story, but you don't want to be too detailed as to why this is the case. Very subtle, old-fashioned wording, but if we go to the statement of claim again, we see this. So in the slide, there's a allegation of misrepresentation. The plaintiff is saying the defendant misrepresented a lot of things. They misrepresented the amount of work I'd have, the salary I'd get paid. They misrepresented the position that I would hold and the flexibility that I'd have in my job. Right? So this is a statement. Misrepresentation is very weighty, and so it needs to be a little bit more specific. You can't just say, I was wronged. They want to know a little bit more specifically how you were wronged, but not necessarily to the point that you're giving evidence of these instances. So the misrepresentation that I'd have a lot of work to do. So from the outset, the volume of work was much less than I'd been represented. The misrepresentation that he'd be in a high position. Instead of being in a position of seniority, he found himself working alongside several other individuals. The misrepresentation that he'd have a high salary. The salary promised was not delivered. Instead, he had a lower salary and provided the chance for potential bonus. With the discrimination piece, the plaintiff is pleading that the defendant knew about discrimination, right, despite knowledge, and the plaintiff brought up concerns, so they knew about it. But it's being careful not to plead specific evidence. There will be a time and a place to do so where you can present documents, you can present recordings, you can present all the kind of proof that will support the assertions you are making. So ultimately, it's not just about following rules and checking boxes. Pleadings are really about narrative advocacy. So you want to tell your story in a way that is convincing to the audience. And the audience can be the judge, it could be the other side, it could be even a third party like a mediator. But for most cases, probably the most important person you have to convince is the other side, because 95% of disputes settle early. So you want to bring the other side closer to seeing your point of view to get a better settlement offer. So your pleading is perhaps your most powerful tool to tell your story in a persuasive way. And Furbacker, the case of Furbacker over here, kind of outlines different functions that we've established through this lecture. So you want to define with clarity and precision what the litigants are arguing about. You want to give fair notice of the case to be met and the remedies sought. And you want to assist the court in investigating the truth. Other purposes, you want to remove surprises, you want to allow fair trial, you want to give your client the opportunity to tell their story, right, in a written way. A lot of times oral arguments get cut short or there's too many busy court schedules, so this is the best chance for your client to tell their story in a free way. And again, there's no page limit necessarily for a statement of claim, so you can be, or you can narrate it as best as you want. So you want to draft with a convincing, maybe emotional tone. And ultimately, really good narrative advocacy or storytelling will be the one which resonates with the audience the most, or with things people already know, right? This plaintiff's story is about broken promises. It's a little guy versus a big company. He had a derailed career. He was discriminated against. So he's really kind of going for that heart-wrenching, gut-wrenching story that we all know and, empathize with. And as we'll see next time in the Statement of Defense lecture, the defendant's going to have their day in court. They're going to have their chance to put on their own little storytelling here, and they're going to focus on their own version of events. So for them, as we'll see, the case wasn't really about discrimination or broken promises. It was actually about, starting something with the best intentions, but having a worker who just couldn't cut it, who took too much time off without properly notifying, who wasn't meeting his deadlines. So theirs will be written in a way that pulls out different facts and emphasizes or suggests different, seeing the plaintiff in a different light. So both sides have their own convincing story to tell, and you want to use your material facts to really support them. But let's just have a quick recap here of what we've learned today. So in a conventional civil action, you're going to start the claim with a pleading, with a statement of claim, and you're going to have a documentary conversation with the other side. So the plaintiff starts with a statement of claim, and after that, the defendant will respond with a statement of defense, where they defend themselves against the allegations made in the statement of claim, but they also want to tell their side of the story and outline their version of events. We might also have a counterclaim. This is something we'll talk about at a later time. But a counterclaim is basically saying, listen, not only did we not do what you're claiming, we're defending ourselves against that, but we're actually going to sue you back because you've actually done a lot of bad things to us. So in this case, in the scenario, the plaintiff, who is still a plaintiff, kind of acts as a defendant to this counterclaim. And then after that, the plaintiff will have a chance to defend themselves against the counterclaim or reply. A reply is basically an opportunity to shore up your statement. And if the defense has undermined your original statement of claim in any way, you can kind of reply to that and add or kind of amend the way that would help you out. All right, so that is everything for statements of claim and the first lecture of pleadings. Stay tuned for the following lecture, which will delve into more of a statement of defense viewpoint, and check out the other videos for other helpful tips in civil procedure and litigation. And as always, thanks for watching.